Hello everyone, I am Dr. Amruta Sirpurkar and I welcome you to my lecture series on the law of tort. In this lecture, we will try to understand what is tort and what are the constituents of tort. But before going into that discussion, let's first know what is law of tort and what the law of tort is for. Basically, law of tort is fashioned as an instrument having two functions. Firstly, it makes people adhere to the standards of reasonable behavior, and secondly, it makes people respect interests of one another. And it does this by protecting our interests and by providing for the situations when a person whose interest is violated can seek compensation for the loss suffered by him from the one who has violated his interest. By interest, here we mean our claims, wants, wishes, and desires that we want to satisfy. However, one should take note of the fact that law does not protect all of our interests. It protects only those interests which it considers it necessary to protect. And these protected interests of ours are what we call our legal rights. And corresponding to these rights are our legal duties. And law of tort protects our legal rights by providing for the remedies in the form of compensation in cases of violation of these legal rights. Now, second thing that we must know about law of tort is that it is a civil law. Now, why do we call it a civil law? Because it protects our civil rights, our private rights. These are the rights which belong to individuals as an individual and not the public rights which belong to public as a whole or society as a whole. Secondly, it provides civil remedy in the form of compensation and not the penal remedy which is in the form of punishment. Now with this insight, now let's try to understand what is tort and what are the constituents of tort. The word tort is a French equivalent of English word wrong and is derived from a Latin word tortum, means to twist. Let's make things easy. Word tort means wrong. A tortious act is a wrongful act. So, at the very first instance, as a very first constituent of tort, we can say that it is a wrongful act. Now, when can we say that our act is a wrongful act? When we do something that we should not, and when we fail to do something that we should. Now, what we should do and what we should not do are our duties. It means when we commit a breach of our duty, our act is a wrongful act. Now, the question is whether all breaches of different kinds of duties that are on us constitute a tort. Basically, broadly speaking, there are three kinds of duties that are on us. Number one, moral duties. These are the duties imposed on us by moral values. Moral values are the values that which govern our conduct in our day-to-day life, in our personal sphere as also in our public sphere. Example of a moral duty? It is our moral duty to respect our elders. It is our moral duty to help the needy. Now, if I commit a breach of moral duty, have I committed a tort? If you see a child drowning, now instead of rushing to the child to save his life, you turn a blind eye to him and just pass away from there. Consequently, the child dies by drowning. Here, it was your moral duty to do the best that you could to save the life of the child, but there was failure on your part to fulfill your moral duty. Now, here the question is whether law will make you liable to compensate for the loss resulting from the death of the child. Certainly, the answer is no. So, here we can say that breach of a moral duty does not constitute tort. Now, second type of duties are contractual duties. These are the duties which are imposed on a person by a contract. The terms and the conditions of the contract involve number of rights, and corresponding to these rights are the duties which we call contractual duties, and which parties to the contract voluntarily undertake to fulfill. Now, whether breach of these contractual duties can constitute a tort. Now, let's first take an example of a contractual duty. If there is a contract of sale and purchase of, say, machine between A and B. Now, under the contract, A agrees to sell a particular machine to B, and B agrees to pay a fixed amount towards consideration for the machine to A. Now, under this contract, it is duty of A to transfer the machine to B, and it is duty of B to pay the amount of consideration to A. These are their contractual duties. Now, in the absence of contract, no such duty can be said to exist. One more thing about contractual duty that we should know is these are the duties which a person has to a particular or specific person or persons only, not to the world or people at large. In this example, the duty of A to transfer the machine is towards B only and not to C, D, E or any member of the society. In the same way, the duty of B to pay the amount of consideration is towards A only and no other person in the world but to A only. Now the question, whether breach of a contractual duty constitutes tort. Since a contract is an agreement enforceable at law, if a party to the contract commits breach of his contractual duty, certainly an action lies before court of law against the person who has committed breach of his contractual duty. However, the case would be for a breach of contract, for this would be a wrongful act constituting a wrong of breach of contract and not the tort. The court deals with the cases of breach of contract differently than the cases of wrongful acts constituting tort. So now here we can say that a breach of contractual duty does not constitute tort. Now third type of duties are legal duties. These are the duties which are imposed on a person by law. Just in the beginning of the lecture, I said that certain interests of ours law protects, and these interests are what these protected interests are what we call our legal rights, and corresponding to these legal rights are our legal duties, and these are those duties here we are talking about. Now, example of a legal duty. It is our legal duty not to cause harm, not to cause damage to the person, property, or reputation of any other person without reasonable or just cause or excuse. Now, why law imposes this duty on us? It is because all of us, we enjoy a legal right to the security of our person, property, and reputation. And it is towards this right law imposes on us a legal duty not to cause harm to the person, property, or reputation of any other person. Now here need to we need to take note that these are the duties we have towards world at large, towards people at large, and like in case of contractual duties which are towards a specific person or persons only. So legal duties are the duties which we have towards the world or people at large. Now, if we commit a breach of legal duty, whether we commit a tort, now take an example. If by driving vehicle negligently, I cause a bodily injury to a passerby on road, have I committed a tort? Yes, because law imposes on me a duty to take care while driving or while doing anything for that matter, so that I should not cause injury or damage to the person, property, or reputation of any other person. Now here, since I drove vehicle negligently and thereby I caused bodily injury to a passerby, I have definitely committed a breach of legal duty and I have committed a tort. So now here we can say that a breach of legal duty constitutes a tort. From the discussion so far, we can say that neither breach of moral duty nor breach of contractual duty, but breach of legal duty constitutes tort. So, a wrongful act, in order to constitute tort, must consist of a breach of legal duty. Now, second constituent of tort is injury. By injury, we mean violation of legal right. A wrongful act, in order to constitute tort, must result into an injury, means a violation of legal right. There are two maxims that govern the field: Demnum sine injuria and injuria sine demno. Now first understand the maxim demnum sine injuria. Since the maxim is in Latin language, let's first know the meaning of the words used in this maxim. Demnum sine injuria. The word demnum means damage in the substantial sense of money, comfort, health, life, or the like. Sine means without, and injuria means injury, that is violation of legal right. Now let's read the maxim demnum sine injuria as damage without injury, that is substantial loss without violation of legal right. The cases falling within this maxim are the cases wherein an act in question inflicts a substantial loss without violation of legal right, And since there is no violation of legal right, in the absence of injury, the mere substantial loss will not render the act in question a tortious, and therefore no cause of action can be said to arise even though the act in question results into a substantial loss. And therefore the person who has suffered or sustained a substantial loss will be having no cause of action to get compensation from the person whose act caused him that substantial loss. Why? Because no legal right of him was violated. The decision of the court in Gloucester Grammar School case illustrates the maxim. In this case, the defendant was a teacher in the plaintiff's school. Due to some dispute with the plaintiff's school, he left the school and set up a rival school just next to that of the plaintiff. Now, defendant being a popular teacher among the students of the plaintiff school, number of students from the plaintiff school took admission to the defendant school, thereby causing a substantial financial loss to the plaintiff. Now, being aggrieved by the act of the defendant, plaintiff moved the court seeking compensation from the defendant. However, the court dismissed the case, holding defendant not liable to pay compensation. Court observed that the defendant, in setting up his school, in fact exercised his legal right, and in exercising his legal right, he did not violate any legal right of the plaintiff, and therefore no cause of action can be said to arise in favor of plaintiff, entitling him to seek damages from the defendant, and therefore no tort can be said to have committed by the act of the defendant. Now, the second maxim, injuria sine demno. Injuria sine demno. Injuria means violation of legal right, sine means without, and demno means damage in the substantial sense of money, comfort, health, life, or the like. So, now let's read the maxim injuria sine demno as violation of legal rights without substantial loss. The cases falling within this maxim are the cases wherein an act in question results into violation of legal right without inflicting any substantial loss. And since there is a violation of legal right, the act in question, since there is a violation of legal right, a cause of action would certainly arise in favor of the person whose legal right is violated to seek compensation from the one who has violated his right. It means that violation of legal right in itself is sufficient to render the act in question a tortious act, even though no substantial loss results from the act. The decision of the court in Ashby versus White illustrates the maxim. In this case, plaintiff was a legally qualified voter. In parliamentary elections, defendant, a returning officer, wrongfully refused to register the duly tendered vote of the plaintiff. Now, the candidate in whose favor plaintiff tendered his vote anyways got elected, and as such, no substantial injury was caused to the plaintiff by the defendant's refusal to register vote of the plaintiff. But nevertheless, in a case filed against defendant, the court awarded damages to the plaintiff for there was violation of his legal right. It means a legal right. This was the legal right which was conferred on the plaintiff by law, the right to vote. Thus, here we can say that if there is a violation of legal right, even though the act in question does not inflict substantial loss, still a cause of action arises in favor of the person whose right is violated. Now, here we can say that a wrongful act, in order to constitute tort, must result into a violation of legal right. Now, third constituent of tort is remedy. The entire law of torts is based on the maxim ubi jus ibi remedium. It means where there is right, there is remedy. Whenever law confers on us a legal right, it never confers a bare right. That right is always coupled with a remedy. It means if your right, legal right, gets violated, you will be having a remedy in the form of compensation for the violation of your right, because in the absence of remedy, the right would be a meaningless one. Now, in cases of tort, the remedy that is provided by the law is in the form of unliquidated damages. Now, why do we call the damages, that is compensation here, as unliquidated? It is because the damages are not calculated on the basis of any fixed formula. It is entirely for the court to determine the amount of compensation, taking into consideration the facts and the circumstances of the case. Unlike in case of breach of contract, wherein the damages awarded are liquidated damages. It is because there the amount of damages in one way or the other had some connection with the predetermined terms and conditions of that contract, which is not so in cases of damages awarded in case of tort. And therefore the damages in the form of remedy that are provided in cases of tort by law are called as unliquidated damages. Now, after the entire discussion, now let's try to define the word tort. Tort is a civil wrong which consists in a breach of legal duty independent of contract, resulting into violation of legal right, and for which law provides remedy in the form of unliquidated damages. I hope you have understood the topic we discussed in today's lecture. Thank you.